Welcome, Ms. Téa Braun. I'd like to begin by thanking you for taking the time to come and interview with the Cambridge Journal of Law, Politics and Arts to discuss your remarkable work at Human Dignity Trust, an organization dedicated to defending the human rights of LGBT people globally. I would like to begin by asking you about how you got involved in fighting for LGBTQ plus rights. You've worked in various areas of human rights for a number of years. Was this something that you were interested in pursuing whilst you were working in private legal practice in the early stages of your career?
Thank you. I didn't initially set out to be working in international human rights law. My practice originally was as a commercial litigator, which I very much enjoyed in the early stages of my career and enjoyed working with clients in that area. But I think after a few years working in that area, despite enjoying it, I realized that the sort of commercial context wasn't something that was going to satisfy me for an entire career. That I wanted to do something a little bit more people focused and work in ways where the law could have an impact on real people's lives. So it was very much a decision to move away from a commercial practice and into the international human rights space. And as a result of that decision, I went and studied a master's degree in international human rights law, and it all evolved from there.
Thank you. And following your work as a gender equality advisor and as human rights advisor for the Commonwealth Secretariat, what led you to work specifically in the LGBTQ rights segment?
So since completing my master's degree, I worked in a number of areas that always had a focus in sort of discrimination, in the ways in which people are discriminated against or have lesser opportunities or access because of their personal attributes. That was always partly informed by a very strong interest in women's human rights in particular, and the ways in which sex and gender define life chances for many people around the world. So there's always been a thread for me of women's human rights. But with that in mind, I worked across my career. I've worked in issues ranging from child trafficking, where I took a particular interest in the ways in which girls are trafficked for labor exploitation, to working on indigenous land rights in Africa, and again, very much looking not only at sort of indigenous interests overall and the exploitation of their land rights and the obliteration in many cases of their traditional lands, but also the ways in which women within those communities might have different perspectives, different experiences, or different access to engagement, even on what the priorities were, and helping all members of the community to engage at international mechanisms like the African Commission on Human and People's Rights at the time. And then working very directly on women's human rights in the Pacific region, where I was the gender equality advisor to an intergovernmental organization, working across the full range of women's rights, from economic rights issues to health to violence, political participation, and all sorts of things. So that there was sort of a natural evolution of that into a very similar group of people who for different reasons, but in a very similar way, are marginalized and discriminated against simply because of their identity, their sexual orientation, or gender identity. And so I was approached by a group of people, lawyers, that were creating what was then a startup, the Human Dignity Trust, to develop and run the legal work. So it was very much a novel thing for all of us at the time. But the Human Dignity Trust was formed by a wonderful barrister, human rights silk, by the name of Tim Aughty at Blackstone Chambers. And with him and others that were involved at the time, we developed this work. And what really appealed to me was both the application of my background in equality and non-discrimination, but also the use of strategic litigation, having, you know, a background as a litigator, that combination of, you know, a particular human rights issue and the use of the courts as a mechanism to try to affect change.
That's a very remarkable background in human rights and very wide ranging. Just following up on the end of your response on the trust, I was wondering, as the trust works in a huge variety of jurisdictions, and part of your role as chief executive is to oversee all the core legal work, what does this entail in terms of how you work with the core team in London, together with the activists and litigants within jurisdictions across the world?
So we have a core team in London that has grown. When we were that startup many years ago, it was just, you know, a couple of us that were developing the work and implementing the work. And happily, we've had a lot of success and have grown as a result. So we're now fortunate to have a legal department that has a head of legal and some senior lawyers. So I work very closely with them. I of course, in the early days, I developed our legal strategy. I developed our sort of processes for assessing the prospects for successful strategic litigation. And over time, I developed our work in legislative reform as well. So I'm still very involved in that overall strategy and our overall approach to our technical legal work, but have now a wonderful core team of lawyers that are able to implement the work in different regions of the world. And every single part of our work involves directly and centrally local partners who are making all of the decision, the technical legal support on request if they want it. So we have always from day one worked very closely with local partners, local civil society organizations, local litigants, and in the context of legislative reform, governments. So yeah, it's a very close collaboration between myself, my team, also our legal panel. We work with big international law firms and barristers in private practice who work pro bono with us. So we have this sort of relatively huge team working with these wonderful local partners and local lawyers very collaboratively over many years to try to advance these legal interventions.
Thank you. So the work that the Trust does is obviously incredibly important, and it's been involved in some really impressive legal victories over the years since it was founded. In previous interviews, you've spoken about how the case in Belize was instrumental in kickstarting a series of court victories across the region, such as in Barbados. Why is strategic litigation such a key part of the work that the Trust does?
I suppose in an ideal world where there are laws that discriminate against a particular group or groups, and it's clear based on the country's constitution or its international legal obligations that those laws are non-compliant with those obligations. In the ideal world, the government would be reforming those laws. It would be taking those steps to make sure that its laws and practices are compliant with constitutional and international norms. But unfortunately, often that doesn't happen. And a key area in which it doesn't happen is LGBT human rights, because it's often not considered politically expedient. In many of these countries, there's a social and cultural hostility towards marginalized groups such as LGBT people. So there's little motivation, there's little political will often to do the right thing. So the courts have to be the place where recourse is sought and achieved. The whole model of the Human Dignity Trust is that we want to help take this, what can often be a very heated issue, a heated emotive issue, away from that space and into what should be the rational space of the courtroom, where all that matters is the law. Personal opinion doesn't matter, majority opinion doesn't matter. What matters is the law, and principally the Constitution and international human rights obligations. So strategic litigation is vital for those who don't otherwise have a voice, who don't have sufficient numbers to affect political decisions such as law reform. And that has been a huge part of our success and the success of many others working in this space, where the courts are independent and able to analyze purely the law and say that regardless of majority views, regardless of religious views, everybody has the same fundamental human rights, and it's the court's obligation to uphold those. So, we very much need strategic litigation. And in the context of something like Belize, it was the first case of its kind in the Caribbean region on this particular issue. No other country had a case of this kind on this topic in the region. So it was novel, and it was ultimately precedent setting, where the court did say that these laws violate the Belizean Constitution and international human rights law. So it not only struck down the law in Belize, but it created a bit of a platform and ultimately a bit of a domino effect, happily, in the region, where others were inspired to bring similar cases, and courts in those countries were able to look to that precedent in Belize, as well as other comparative legal cases from around the world, and say the same thing. And we are seeing that domino effect with a number of other wins in the region.
Thank you. And just touching on what you said about how strategic litigation is important because social influences don't impact the courtroom. I was just wondering, considering the sort of wide variety of reasons why there is discrimination against LGBT people, so colonial influences or varying religious influences, do you feel at all like that affects your legal strategy in the courtroom, depending on sort of what the type of country is and what their social makeup is? Or would you say that you take a very similar litigation strategy into each country, it being a courtroom that is meant to be impartial?
Yeah, absolutely. We have to take those into consideration. There is some degree of those influences in every country. And as much as it is ultimately a question of law, judges are human as well. And, the opponents in the courtroom are making those arguments. It is very common for the opposition to LGBT human rights and for decriminalization in particular of LGBT people to be centered around cultural, religious, and social norms, as well as health-related arguments. So the typical argument in response, in defense of these types of cases, whether from government or from interveners, and we do see churches, for instance, intervening in these cases to oppose LGBT human rights. They're mounting arguments based on things like public morality exceptions in the Constitution or restrictions on human rights that are found in international human rights law and constitutional law, to say, yes, there's a right to non-discrimination, or yes, there's a right to dignity or privacy or whatever, but they are restricted rights, and they're subject to exceptions like public morality, and public morality means majoritarian views, means religious views, and that sort of thing. So we have to always be countering that by an understanding that public morality doesn't mean majoritarian views, because if that were the case, no minority would have any human rights. But rather it means constitutional morality. What are the founding principles of the Constitution? And they are based in human dignity, human rights, equality for all, and fundamentally the protection of minorities. They'll similarly make arguments based on health-related grounds. They'll tend to argue that you need to criminalize LGBT people because gay men and trans women in particular have much higher rates of HIV prevalence. So in their view, you have to criminalize them in order to stop the activity that leads to this health issue, whereas public health analyses make very, very clear that criminalization actually exacerbates the public health crisis. It pushes people underground, outside of the reach of public health information and prevention. So you're actually exacerbating and increasing HIV prevalence by criminalizing people who are going to engage in the activity that is consistent with their identity. So we have to engage those arguments. We have to bring the courts along with why those arguments both aren't legally or scientifically sound.
So one of the main goals of the journal that we're compiling is finding ways to keep governments accountable for policies that endanger civil rights, including LGBT rights. And we're really interested to hear about how you spearheaded the Trust's expansion into providing technical legal assistance to governments, and have now helped multiple countries draft new bills on sexual offence laws, hate crime, and equal opportunities. Can you tell us a bit more about the ways in which you initiate this type of work with governments? So do you approach them through activists in the jurisdiction, or do they approach you?
So that work came much later in our existence as an organization, and it originated from a recognition that not only, as I mentioned earlier, is the ideal way to change these laws to be through reform rather than LGBT people having to undergo, litigation to sue the government. The government should be doing the right thing. So there's that sort of background realization, but also that a number of countries have decriminalized LGBT people through reform, and sometimes through wholesale legislative reform of either their entire penal code, which in many cases is vastly out of date, or at least the sexual offenses type provisions within the penal code, which again are in many cases they're still written in Victorian language and based on Victorian values that were spread around during colonial times. So they're vastly out of date in a number of different ways, including this type of criminalization. So we started researching to what extent could our access to technical legal assistance and expertise aid in advancing legislative reform in those countries where there was some degree of political will to look at that type of reform. And that coincided with the UK being the chair in office of the Commonwealth at the time. From 2018 to 2020, the UK was chair in office of the Commonwealth. And the Commonwealth is a big part of the criminalizing picture because of that colonial history that I just touched on. And as a result of our discussions with the UK government, there ended up being an apology from Theresa May, who was Prime Minister at the time, and a recognition from her that the UK had spread these laws around the world, both these laws and laws that discriminate against women and girls, and that those laws were wrong then and they're wrong now, and that the UK would assist any Commonwealth government that wanted to review its laws to do so, and we and a few others ended up being the mechanism of providing that support. So there was a kind of public announcement to Commonwealth leaders that there was this sort of support available for any Commonwealth governments, at least, that wanted it. So some of the approaches came to us as a result of that, and others have come through us looking at which countries we think might be amenable to legislative reform, and in one way or another, approaching them to see if they have any interest in technical assistance, and importantly, working with civil society in those countries to see whether they think legislative reform is a reasonable prospect, and if so, if they would welcome technical legal assistance. All of that has invited, very positive responses from a few countries. And often the situation they find themselves in, particularly smaller countries, is there might be some degree, at least, of political will. There is often some degree of recognition that these laws have to go, they have to be reformed, they have to be updated. And I'm talking here about LGBT criminalization, but I'm also talking about rape laws, sexual assault laws, ages of consent. There's a lot of stuff that's out of date and not human rights compliant. And these countries, even if they have that political will, they often don't have the technical capacity or the human resource capacity. They might have one or two legislative drafters for the entire country, and they have to deal with all legislation for the country. So when that offer is made of technical expertise and legal assistance, it's often welcomed. And so it has enabled us to work with a few governments to work with them very closely to draft human rights compliant bills in these areas.
Thank you. And something that is really interesting is the fact that this is an element of the work that you do that came after the kind of strategic litigation side was kind of really taking blossoming. And I was wondering, have you found that there's any challenges or restrictions that have come from working with governments that are trying to draft new laws, as opposed to kind of almost standing against those failing to protect human rights in court?
Yes and no. There's obviously the potential for that, and we're very open that we do both. Ultimately, they're achieving the same end, so it's just different ways of achieving the same end. And we have worked in some countries where both are ongoing. Strategic litigation is working in parallel with legislative reform, and obviously we manage that very carefully, and we're very transparent about it. But it's sort of it's very much different ways of achieving the same end. And we do often find that there are attorneys general or ministers of justice who are sympathetic to the need for change. They may or may not have complete influence in whether that change is effected through legislative reform. And they have to, if a case is filed, they have to defend the case, or they consider that they have to defend the case. So we would say they should be arguing strongly to their government that shouldn't be defended, that the change is necessary. But in any event, sometimes being able to offer both of those either competing or complementary types of input can help. They can help governments, particularly, as I said, those movable middle. The hostile governments you're never going to work with anyways, because they have no political will whatsoever in these areas. But those movable middle countries, sometimes they like to see it done through the courts, because it makes it easier for them to say they have to comply with what the court said. And sometimes it helps them advance a legislative agenda where they say, listen, do we really want to have to pursue this over many years in the courts, or do we want to be seen to be doing the right thing, either on the domestic or the international stage? So they can end up complementing each other quite well.
That's really interesting. So would you say it's actually the social kind of makeup or environment in the country that impacts how governments want it to be seen as? Because I guess with the doing it through the government, it can advance them politically if there's social will to move against these legislation that are outdated. But then if it's more of a hostile country, then it is better to do it through the courts.
Yeah, absolutely. I mean, at the end of the day, politicians are vote seekers. So, which isn't to say there isn't the odd exception. There have been countries such as the Seychelles, which decriminalized despite, the usual kind of social conservatism and, religious pressures. And the president simply decided and made a commitment at the UN that he was going to do this, and he did it quite swiftly. I think politicians often fear that there will be a fallout if it's going against social, majoritarian views, that they'll pay the political price. But I think there are many examples, including in Seychelles, where that simply didn't happen. Doing the right thing, the sky doesn't fall. So I think there is that inherent, vote seeking and fear in politicians. But those who are genuine leaders, true leaders, I think can and do make change, even in the face of opposition, and they bring the populace with them, and they do it, correctly and reasonably swiftly, and because of their leadership skills, the sky doesn't fall. So I think you do get quite a mix, but there are many jurisdictions where the political structure and the social structure are just too hostile, where the only potential avenue is the courts.
Thank you. That's really interesting.
We now wanted to transition slightly in terms of Dignity's relationship with the activists and litigants. So you've previously spoken about how the activists and litigants within the jurisdictions that you work in are the heroes and are often working in very dangerous and hostile environments. How did the Trust initially build relationships with its partners?
So, of course, at the very outset, nobody knew us, and we had to build those relationships, and that was very much a process. Well, it was a sort of multi-pronged process of both understanding ourselves, the global legal landscape, of all the criminalizing jurisdictions. You know, we did really detailed work to look at the individual context in those countries, the legal framework, the judicial framework, the civil society framework, the international ratification framework, you know, you name it, to try to identify where might there be prospect for success in this type of litigation. And then, you know, it was very much a matter of reaching out to civil society in those countries and letting them know who we are and what we wanted to try to support, and see whether they had thought about litigation or whether they might be open to it. And it was very much a slow dialogue and very much led by local activists. You know, there wasn't much strategic litigation at that time, but there were a few samples to draw upon where litigation had been effective in different parts of the world on this particular topic. So I would say that almost without exception, people were very much interested in it. They had a long-standing desire for change and maybe hadn't considered using the courts as a mechanism for change. And so we developed those friendships and those partnerships, and importantly, you know, the trust with local activists, because we're very conscious that we are based in London. We are, you know, international actors, and you have to approach this work with a high degree of sensitivity, both to local ownership and to local realities. And these people are, in many cases, working and living in very hostile contexts, and they're the ones who are going to have to put their head above the parapet and, you know, bring a case and have the profile that comes with bringing a case. So a lot of our work still in any new jurisdiction is very much about building up both the trust and the relationship and the confidence and the awareness where it might not already exist, but also a sense of security and preparedness for what it means to be involved in strategic litigation, because these are multi-year cases. You know, they do sometimes come with a degree of security risk, and people, you know, it's going to be reported on in the media. So we have a very strong media and communication support function as well, and you know, where necessary, where appropriate, we help with security assessments and security plans where people need it. So there's a lot of that kind of work done before any case is filed.
And as you mentioned, that the partners come from very hostile environments and that often security support will be required. In your experience, could you explain the type of discrimination and harassment that they face within their countries when they want to begin with litigation?
Yeah, it's the full spectrum. It's very much dependent on the country. Some are more tolerant than others, but it's the full spectrum from petty annoyances to grave violence that is sometimes fatal, and everything in between. You know, I think petty annoyances range from people being harassed on the street, being spoken to, you know, in ways that undermine them, up to things like discrimination in housing and employment if they're perceived as being LGBT, education, health, employment, housing, all the rest of it, being marginalized or ostracized by their family members, by their communities once they're known or suspected to be LGBT, having to often lead a false life of heterosexuality simply to avoid all of those things. There's a lot of experiences of either forced or pressured marriages, and that obviously is an area that has differential impact for women and men. Women having, inherently in most countries less economic power, less social and political power, so they're dependent on male relationships for their very survival. So and ultimately that means living effectively a life of sexual violence, where you are forced to be in a relationship that you wouldn't otherwise choose. And all the way up to violence, other forms of violence, such as, being chased down the street, being attacked, being run over, being shot, being stabbed, people are killed. So it's all of that mix, but how much of it and the extent of it is very much country dependent. There are some that are a lot more hostile than others, but there's always that overarching stigma in these countries, that stigma that you just carry with you if you're an LGBT person, that you're not equal, you're not the same, you're an unapprehended criminal, in your own country. So that stigma, regardless of the sort of degree of visible hostility, is always hanging over people.
And following up with all the gross violations and dangers that they have to endure when, in the end, all that they're attempting to do is pursue justice and their human right. Just thinking more on a broader scale, aside from litigation, from your perspective, what other approaches should individuals, charities, and NGOs be taking to further the protection of LGBT rights in their own countries?
I would say it's, as with everything, it's a real mix of things that to be done. Our piece is one very specific part of a much bigger puzzle. There's, a lot of work needs to be done in education. There's a lot of ignorance floating around out there in all of our societies. So education and awareness is a big bit. Faith communities, engagement with faith communities, because very sadly they end up being the main opponent and resistor to change in these areas. So engaging with the more moderate or progressive faith communities and trying to grow the support and acceptance of diversity and, the fact that we aren't all the same, and their influence in communities, I think, is quite key. UN and regional advocacy is a big part of it. Support to communities, support to LGBT communities to just have legal support, to have health access, to have, when they're ostracized from their families or their communities, often they need shelter even. There's a full range of things that people need to be doing to advance the overall picture. Poverty and health issues can be quite severe in the LGBT community in many countries, because they end up being homeless. Often people end up being forced into sex work because they don't have any other economic choices, and they don't have access to the same sort of healthcare that other people might have, or economic opportunity. So yeah, it's really a broad mix, and it's many years of work.
Thank you. And just on a final note, what do you think is the most memorable achievement of the Trust since you've become chief executive?
Oh, that's a hard one. I'm really proud of all of the cases that we have helped to support and to win, and all have real moments of glory and vindication for the people involved in these countries. That Belize case that I mentioned was really monumental because it set the stage, but then the cases that have followed have been equally powerful in the Caribbean, Antigua and St. Kitts and Barbados, and there's more coming. Another as well as the decisions from around the world, but another really important victory that I'm proud of is our quite groundbreaking case at the UN. We brought the first ever case of its kind at the CEDAW committee. In the UN space, there had only been one decision on decriminalization at any UN Human Rights Tribunal, and that was the Toonen case, Toonen versus Australia, at the UN Human Rights Committee under the ICCPR, and that was from the 90s. So no case had been brought since, and we brought the first case of its kind as part of our effort to expand international law and develop international law. We brought the first case of its kind to the CEDAW committee to establish that criminalizing women engaged in same-sex intimacy was a violation of the CEDAW Convention, and we won that case. I might get the year wrong here. I think it was last year, 2022. We won that case. So that was a really big moment, because it's one that I had the early seeds of many years ago and started the research on many years ago. And again, integrating that perspective of women's human rights and looking at how these laws not only impact, this group that we call the LGBT community, but how they impact different constituencies within that group, because women are affected differently than men. Trans people are impacted differently than gay and lesbian and bisexual people. And so we've really tried to look at, what are the different ways in which these groups are impacted? What are the different ways in which they're criminalized? And what are the different ways in which those issues need to be engaged and used and advanced in both domestic and international courts. So that CEDAW case was a big part of that that I'm quite proud of. Yeah, I could probably talk about more, but those are a few.
Well, those are incredible few achievements to discuss. Thank you, Téa, for taking the time to interview with us and to discuss the remarkable work Dignity Trust does to protect human rights for the LGBT community around the world. This has been a fascinating discussion, not only in terms of insight of how LGBT rights are being violated and the complexity in tackling this, but also your discussion of the different legal avenues available to pursue accountability for the lack of human rights compliance and ultimately helping achieve justice is truly important to get across. So thank you again so much for your time.
My pleasure. Thank you very much for inviting me.